This video is the fourth series of Straight to the Questions, 50 most frequently asked multiple choice questions on Criminal Procedure Code 1973 by Ask Me Anything. It is very important for All India Bar Examination and other judicial service examination. If you want to watch the similar MCQs on Indian Penal Code, Law of Tort, Constitutional Law, then click the I button or go to the link given in description below. Before going to the 50 most frequently asked questions, let us try to understand brief notes on Criminal Procedure Code 1973. Criminal Procedure Code 1973 is procedural law or adjective law, which means Criminal Procedure Code deals with the enforcement of substantive criminal law that is guided by the practice, procedure and by system of its working. At present, Criminal Procedure Code has 484 sections, 2 schedules and 56 forms. Schedule 1 deals with classification of offence and Schedule 2 deals with forms. Okay, let us come to question number 1. Taking a cognizance of an offence under the Code of Criminal Procedure 1973 means taking judicial notice of an offence. Question number 2. Which subordinate courts may award a sentence of imprisonment for life? It is a court of session. Question number 3. If the offence is non-bailable offence, it means bail may be granted to accused only through exercise of judicial discretion. It is unlike to bailable offence. Question number 4. Which civil nature of proceeding as an exception is dealt by Criminal Procedure Code? Maintenance, which is given in section 125 of CrPC, is a civil nature of proceeding, which is included in Criminal Procedure Code. Coming to question number 5. It is illustration type of the question. Listen carefully. During the trial for murder, the prosecutor alleges that the murder weapon is hidden in the house of the accused, but his wife, that is the wife of accused, is not allowing them into the house. What should the prosecution seek from the court to secure the murder weapon? A search warrant to inspect the house of the accused for the murder weapon must be sought. Question number 6. A has murdered her husband. She goes to the police stations with the murder weapon and confesses before the police in view of the principle mentioned in section 164 of the Criminal Procedure Code 1973. What would be the correct action for the police? The police should produce A before Metropolitan Magistrate or Judicial Magistrate to record the confession. Question number 7. A witness to a murder files a FIR, but A was in a state of shock and could not record his statement completely. What can be done in this situation? Here, FIR is not a sole, it's not only a basis of a trial. A can record his statement with missing details during the trial, but the prosecutor or the defense may cross-question him based on the FIR. Coming to question number 8. When are confession admissible? Confession are admissible provided that the accused has given it voluntarily and the magistrate recording it has followed all procedures mentioned in the Criminal Procedure Code 1973. Question number 9. Which classification of offence come under Criminal Procedure Code? Classifications of offence like cognizable and non-cognizable, bailable and non-bailable, and summon cases and warrant cases are classified under Criminal Procedure Code. Question number 10. Under which section of Criminal Procedure Code the cognizable offence is defined? It is defined under section 2 subsection C of Criminal Procedure Code. Question number 11 asks under which sections of Criminal Procedure Code non-cognizable offence is defined. It is defined under section 2 subsection L of Criminal Procedure Code. Question number 12. In a bailable offence, the bail is granted as a matter of right both by police officer and the court. Question number 13. Complaint as provided under section 2 subsection D of Criminal Procedure Code can be either in writing or in oral. Question number 14. It is mandatory to produce the person arrested before the magistrate within 24 hours of his arrest under section 57 of Criminal Procedure Code, which means if a person is arrested, it is needed to be produced before the magistrate within 24 hours, which is given under section 57 of Criminal Procedure Code. Question number 15. Section 91 of Criminal Procedure Code does apply to complainant, the witness, and any person, but Section 91 of Criminal Procedure Code doesn't apply to accused. Question number 16. The investigating officer during the investigation records the statements of a witness under Section 161 of Criminal Procedure Code. Question number 17. A statement of witness recorded under Section 161 of Criminal Procedure Code in writing during investigation and is signed by the person making the statement is hid by Section 162 subsection 1 of Criminal Procedure Code. Here it is very important to understand Section 162 says that statement to police not to be signed and cannot be used for any purposes or for like evidences. Question number 18. Criminal Procedure Code is a subject of concurrent list. Question number 19. Bailable and non-bailable offence has been defined in Section 2 subsection A. Question number 20. Under Section 21 of Criminal Procedure Code, special executive magistrate may be appointed by state government. Question number 21. Addition or alteration of charges is provided in Criminal Procedure Code under Section 216 of Criminal Procedure Code. Question number 22. Police may carry out personal search on an arrested person under Section 51 of Criminal Procedure Code. Question number 23. The special court is not subordinate to High Court. Here a special court means a court created for exception and temporary purposes like drug courts, traffic courts, and so on. Question number 24. The powers under Section 159 of Criminal Procedure Code can be exercised by magistrate when the police decide not to investigate the case. Question number 25. Statement recorded during investigation under Section 161 can be used in a trial for contradicting the witness. Question number 26. Power of taking cognizance of offence by magistrate of first class or second class is provided under Section 190 of Criminal Procedure Code. Question 27. Discharge of arrested person by police officer can take place under Section 59 of Criminal Procedure Code on his own bond or on bail or under special order of magistrate. Question number 29. Which section of Criminal Procedure Code deals with examination of person accused of rape by medical practitioner? It is given in Section 53A of Criminal Procedure Code. Question number 29. According to Section 167 of Criminal Procedure Code, an accused person can be remanded to police custody for not more than 15 days at one time. Question number 30. Which section of Criminal Procedure Code put police officer under obligation to produce the person arrested before a magistrate within 24 hours of arrest? It is provided in Section 57 of Criminal Procedure Code. Question number 31. Who may record confessional statement under Section 164 of the Criminal Procedure Code? Only judicial officer may record confessional statement under Section 164 of Criminal Procedure Code. Question number 32. The provision relating plea bargaining is not applicable in the offences affecting socio-economic condition of the country, offence against women or a child below 14 years, offence in which the maximum sentence is 7 years and where the accused has previously convicted for the same offence. Question number 33. Which section of the Criminal Procedure Code deals with compoundable offence? It is dealt by Section 320 of Criminal Procedure Code. Question number 34. What is the time limit under the Section 468 of Criminal Procedure Code for taking cognizance? It is 3 years. Question number 35. Which section of the Criminal Procedure Code deals with the prosecution of judge? It is provided in Section 197 of Criminal Procedure Code. It is not dealt only with the judges, but it is dealt with the public servant too. Question number 36. Which section of Criminal Procedure Code put an obligation to police officer to inform the accused ground of right to bail? It is provided in Section 50 of Criminal Procedure Code. Question number 37. Inherent power under section 482 Criminal Procedure Code can be exercised by the High Court. Question number 38. Which sections of Criminal Procedure Code provide that police officer can arrest an accused without warrant? It is provided in section 41 of Criminal Procedure Code. Question number 39. Can a court of judicial magistrate, first class and chief judicial magistrate try murder case? No, it can be tried by court of session if it is in case of subordinate courts. Question 40. Which provisions of Criminal Procedure Code deals with plea bargaining? It is dealt by section 265A to section 265L of chapter 21A of Criminal Procedure Code. Question 41. Security for good behavior from habitual offender is dealt under section 110 of Criminal Procedure Code. Question number 42. Attachment of a property of person absconding can be done under section 83 of Criminal Procedure Code. Question number 43. Bar to taking cognizance after lapse of period of limitation is dealt under section 468 of Criminal Procedure Code. Question number 44. Section 105 subsection H of Criminal Procedure Code deals forfeiture of property in certain cases. Question number 45. Committal proceeding under section 209 of Criminal Procedure are in the nature of inquiry only. What do you mean by committal proceeding? Committal proceeding are those proceedings held in magistrate court to determine whether there is a sufficient evidence against an accused person charged with a serious criminal offence. If there is an insufficient evidence, the magistrate may discharge the accused person, and if evidence is sufficient, then the magistrate order them to face trial in higher court. Question 46. Special summons under section 206 of Criminal Procedure Code can be issued by a magistrate only. Question number 47. Joint trial of several persons is permissible under section 223 of Criminal Procedure Code. Question number 48. Examination of witness in the absence of accused can be done under section 299 of Criminal Procedure Code. Question number 49. Bail amount fixed by magistrate can be reduced by court of session and by high court. The last question of this video series is that order passed under section 451 of Criminal Procedure Code is interlocutory order. What do you mean by interlocutory order? It is an order or a judgment between commencement and the termination of a trial. Okay, subscribers, I'm signing off for this video series. If you have any question in your mind relating to All India Bar Examination and Judicial Service Examination, you can put me a question in a comment below. Till then, take care and see you in my next video series of such 50 most frequently asked questions. Thank you for watching Ask Me Anything. Please do like, share and subscribe to support my channel Ask Me Anything. Your one subscribe will give me a new platform of teaching. If already subscribed, then thanks for your subscription. And press the bell icon to get interesting questions and latest updates.